This week, appeals were filed with the Colorado Supreme Court on the ruling that former President Trump can stay on your ballot.
Well, both sides filing paperwork last night. Our 9 News legal analyst Whitney Traylor has come by to talk more about this. One of the unusual things is the concept of both sides appealing the ruling. Is that common, uncommon?
Well, it's a little bit of both, but it is counterintuitive because you generally think, hey, the party who won, they're fine. The party who lost, they're appealing. But a lot of times you have to remember, when you're going to trial, you're dealing with issues of fact. Did they run the red light? Did they sign the contract? On appeal, you're dealing with issues of law. So someone could win, and let's say they cut down their damages and said, oh, you weren't allowed to get the punitive damages. So they may appeal that aspect of it. So here, both sides are appealing. And of course, the Trump side is appealing the finding that he did participate in an insurrection.
And that it was, in fact, described as an insurrection.
Correct. The other side, of course, is saying that even though, because the judge said, even though it was deemed to be an insurrection, this Section 3 of the 14th Amendment doesn't apply to presidents. So she was saying that, hey, this wasn't the framers' intent. And so they're actually challenging on appeal her interpretation of that part of it.
So to me, this is like appeal, but there is a timeline.
Yeah, there is a timeline. So this one, because it was dealing with election laws, went directly to the Colorado Supreme Court. And they're being urged to make a decision by January 5th, which is the deadline for the ballots, because they have to be printed for the March primary. So I expect that the Colorado Supreme Court, and its 7 justices hearing it, will make its decision by then.
Having multiple justices here, it brings the question to me of, when a judge determines what she thinks is the framers' intent, if you lined up 100 judges, you might get 50 judging the framers' intent was this, and 50 who say it was that. That could be up for grabs. Yeah,
and that's the notion behind an appeal, which is why appellate courts have 3 or 5, a multitude of judges, usually an odd number. So our Colorado Supreme Court has 7, and that's the idea, is that we're having a group of judges actually review this judge. But you make a great point, and I'll read a quick quote from the trial court judge, because one of the reasons she didn't want to say that this applied to President Trump, former President Trump, was because of the gravity of it. And she said, part of the court's decision is its reluctance to embrace an interpretation which would disqualify a presidential candidate without a clear, unmistakable indication that such is the intent of Section 3. And so that's what the judges do when we have our separation, our 3 branches. The judges interpret the Constitution and interpret the framers' intent. And so she's saying, look, unless they said specifically this applies to presidents, I'm not going to make that call.
So all the way around, I mean, that's a lot to understand, but that does set precedent. So we're actually talking about something that hasn't really been talked about before.
Right, we're talking about something, and it doesn't, so the trial court doesn't set binding precedent, but now when the Colorado Supreme Court makes a ruling, that will then become authority, and then of course they can appeal to the U.S. Supreme Court, which I suspect they will, and the U.S. Supreme Court has not ruled on Section 3 of the 14th Amendment. So now we will have a ruling, and we'll start to shape our body of law as we go forward. So that's the silver lining.
So it'll have a name, and it'll be Trump v. Seriously will, like for history, right?
Yeah, correct.
Oh, okay.
And it will, you think it is 100% destined to find the Supreme Court, the U.S. Supreme Court?
I would be surprised if it didn't. It's definitely it's at being filed at the state Supreme Court. And so from there, they can go from the state's highest court to the U.S. Supreme Court. And I suspect it would, just for the virtue. I don't think the decision will change. I think he will remain on the ballot, but just for virtue of actually shaping the law and creating the precedent.
Well, just for the record, I just want to say we find you appealing.
Okay. Well, that was the second compliment I've gotten today.
I was wondering where you were going with that.
Second compliment of the day.
Yes, Ariel was
not even 5 o'clock
earlier. You look sharp today.
I guess I'll be wearing this for the next couple weeks.
You should.
Say nice things to people. It's Thanksgiving week. Whitney, it's good to see you.
Good to see you.